got a great show for us today. It really is all about what's going on where the money mechanics is behind the court, and where venue is, because venue is before jurisdiction. You see, venue is that's so important because it's actually where versus what sort of thing. So it's really where is this occurring. But the state is your state of mind, and what is your state of mind, you see. And buttles are sort of invisible boundaries. And where are those invisible boundaries crossed? This is what the show is a bit about today. But so the state, well, which you could say the state, this is your state of mind. And what is your state of mind? Is that like when somebody says America, the definition of this is from the land. And so when you're talking about America, you sort of got the coastline and everything, and it's the land. And that's one definition. Another definition is a definition which is to do with a constitutional America. And so things which is where the courts are supposed to be following a set of like contracts which exists under the Magna Carta. And so where somebody says America, they could be considered to be talking about, the constitutional America. Otherwise, then it could be also, as a definition of America, the corporate America, and like the USA, which is a corporation. And so, in a Commonwealth nations, you've got every state which is a nation, and you have a republic, and you have a nation. And you have nations, and I think there's 5 nations which are under common law more, but every nation is supposed to be under common law, and the Commonwealth nations have a heritage that relates to these things. So venue is from, and so when you could say, "Oh, you're from," well, that's the strongest verb that you could say. That means you're from, well, you must be from the land, of course. And most crimes and things that happen are happening to you more on the land, and should be settled more by, laws and things that help to protect the most where someone is, because everyone should be presumed innocent until something else would be the case, but they should be assumed innocent until something else would be existed. And so the state and the court could be making money, which you could look to see, and a lot of usufructing, meaning someone's just been pulling monies from your account that's in the public and making money, and that being tax-free, where the courts are operating as trading houses, because that just makes the most money where things are, because there's just so many payments that have to be made and that sort of thing, for where something should be just zeroed out. And so where courts are sort of operating more, where you can look and to see that these are private trading houses, where sureties come to be bundled up as derivatives, and those derivatives as sureties all end up being bundled and sold as some security, and mortgage-backed companies and things buy those things up. And that's a property that you and I have behind the scene of it all, where money mechanics exists. And we, the people, of course, have rights, and where that's violated under the Constitution, it's a criminal acting, under the colour of law. And, because enumeration is money that's given, but yet that those laws that could have been made or operating are not constitutional at all. And so court officers and the clerk of the court all have to follow the Constitution, and where limitations are that exist upon any official's discretion, and where it could be just automatically being that venue, which is either from the land that's where equity is, or under statute, under statute, where the issue is something which is fictional and dead of itself, and not, you don't have a living witness. But in most cases, you sure do have a living witness. And if a crime existed, then you'd have to have another living witness. And somebody's in their person where something is, and also in their public self. And so if something is only just drafted to become more under a commercial condition and under a statute or a statute, because something was dead, and so anybody's property could have been just probated, and so big corps and corps all will just pull everything from whatever existed and pay themselves out and use all of that if it was left in the public. So, point being that a trust has existed, and somebody should really understand a little bit more about trust law for sure, and administrative law and private law and jurisdictional laws, and know the difference between all of that, you see, and who does. It's sort of really what would be someone that would be considered a barrister in the past, that is someone who really had studied like both sides of a bench, and they would have easy ability to see where any right would only flow because of title, and the title of where man has to be in a document, because if it isn't, then it's only something fictional, and any error makes any document null and void. And where title conversion is as a crime of that, something is just going on that's probated often, and someone's private property really can be not protected like it should be. And it's only really on the private side which is the debtor and creditor together, because who's there owns the debt, and that's a credit to them. And this is we the people, or one of the people, and these are the only sorts of precedents and things which create law and make law, whereas everything else really is more sort of something from by or of, but not from, you see. So from is the strongest verb that you could use. Where you use the word of to join things together, it means that something fictional was before it. And when you use by, the same thing, but where from is, that's not. That's like you're from your mother, not of your mother or of your father. You're from the land, not of the land or by the land. No, you see. So the word from in a document and putting the word is into the document, unless you've got is in a document, it's like the document is really not where is, so there's no proper verb. And should there be proper nouns? Yes, there should be. It should be styled by someone who has a proper noun, and that's a real true name. So otherwise, what's gone on is, all that you could say is if most people were listed as infant decedents, meaning they were only corpse, and appearing where anything is only as an infant decedent, and because a lot which is talked about is something which didn't happen in front of you, it's called ex parte hearsay. So a fact exists that a lot of things are going on where ex parte hearsay is, and it's only from an infant decedent to an infant decedent. And these are things which can satisfy an Article 1 type of situation, because something isn't being considered to be verified. But where something is verified, which it should be, which relates to the living, there's so many reasons why that's so. Because, issues that go beyond 9 months at least to be resolved or settled and things that's like that come to be more a security. and laws and things which really govern these. And then there's a uniform commercial code and things that's like that, which help govern and have laws that's written more or less to help protect that somebody could point out those things. But otherwise, it's a bit of an adverse counterclaim that's come up because some contraband has existed because you've got an infant decedent with an infant decedent having hearsay sign off on something, and those are notes which is not really being passed on with a title like it should be properly. And the laws that govern those things should be with consent and, transparency and this sort of thing. And when somebody could say that didn't exist, it's sort of really not quite right where that is. But it's good that somebody could give value because you've got a tax deduction and you can pass the tax deduction on to those who, corporations and things that's made monies from this. And you could have a given value for having given and be seen of some consideration where this matter is, because it's possible for you to completely discharge the charges where a bid bond is put underneath your name and you ask for that where the clerk of court is. And so if you're just looking at something that went on and it really is an adverse counterclaim, it's sort of like a contraband has occurred where the courthouse is and where you've got a bid and a performance and a payment bond written up, the courthouse, and a date where ruledness is, but where no claim is, no binders were beforehand. And if those notes and title wasn't bonded at all, how could any claim be existed where it was, and only at the very end was something ratified? These are things which is to do with issues that relate to something being considered like what we're talking about as abandoned property by you, which it isn't by you asking for the bid bond to be put into your name and to discharge charges, and the charges exist. And lots of things isn't where some crime was existed, but under the bid bond, what you've done is to help make sure that anybody that did have any charges, all those charges are discharged. And this is a remedy. So somebody could note, of course, that anything that was discharged that was a charge and that engaged derivatives that, as we were talking about in the podcast here, come to be considered as security because it goes past 9 months where things are from maturation and where the manner of property that exists. So it requires somebody really to have bonded the issue to become the surety themselves, and for sure have said this is from the land and these crimes happen to me more on the land, and it's not just a commercial condition. So notes where things get passed on properly and have the proper title, otherwise it kind of really wasn't. And these are things which can cause anything to be null and void where it was because errors existed, you see. So things sometimes where this is, like what we're talking about, involve more three-party verification, and you've got to have Article 3 and oversight, and sometimes Article 8 and things where issues that relate to these sureties are that become bonds that's collected and signed and put into bundles like we talked about, and eventually, of course, bundled on sold as some security. So behind all of that, you've got something which you could help get cleared up because you could accept for value anything that's been put to be discharging the charges. So all charges are discharged. So unless the word discharged it's really not discharged. And some words are used, but it's not discharged. And so they're discharged because why? Well, because otherwise a massive amount of user fracting goes on, and these are things which bring a nation down to its knees because, this monies and things that's made is all fractionally reserved onward. And it's a user fracting from the public trust. And so, you're helping the Treasury and you're helping the nation as you can where you are by looking at things and understanding where your good, proper rights are. But otherwise, a lot of contraband you could see is property that could be stymied and mixed with other titles, and no notes be passed on where that is, and an incentive for those that's trading, where a courthouse is and gilded members sort of start to change the Bulliver's dictionary of the way things, what you would use where words are, and comes to be Black's Law Dictionary, and slow but sure you're moving from true equity where you are into something more jurisdictional. And these gilded members all working more for the Crown, and everybody there fitting in where their transactions are to have some licentiousness, and of course sort of tax-free sorts of returns on the investment where the trading house is, because they're using your tax deduction to be able to get that. So it's assumed abandoned property where the bonds are behind anything, like the bid, the performance, and the payment bonds and things that get written out for payments and things to be occurred from currencies of account that become currencies of exchange. And so drafting up what's transparent and drafting up what's existed and being drafted into a probate court where we the people really is made only an infant decedent of some abridged right, and only having a responsibility, a duty, and a privilege as a result of that, as a corporation does, but that is not you, the living being, and it's fascism to have mixed, the living up with the dead. And so a carte blanche, if that's gone on, which it has, it's sort of drafting everyone into some customer profiledness for its own self, not you or I. And so in common law setting, of course, we're looking at any papers that would have gone in which is wrong, is by fraud, and so that's forgery. And so it's a common law trespass, bridging boundaries to garner some profit that's really made more where things go on like a fruit tree. This is the bid, the performance, and the payment bond, where the money mechanics has existed behind the courthouses and things, you see. So it's just that somebody could have assumed a signature of a grantor, and someone becomes a settler of another's property, and court bonds are written up. So if this is your court by design, and you're only here to settle something, that's it. As a claim, if it did exist, which you could discharge that under the bid bond, and so the charges can be discharged, and it can be done without recourse. So no claim was not bonded, and those are questions which somebody could look for, because there really should be nothing that's going on where it's just gone on under the colour of law. And so the court has to show sort of that somebody is a prosecutor, and prosecuting this, who's the living witness, is sure just asking the questions. I need to be able to see if anybody was on the other side of what this is. If somebody's got a claim, I'd love to settle it. And I could say no one would be against my claim. You could say those things because it's probable. But where something is clearly you, the beneficiary, the undersigned, you're the given one to have the title right. And otherwise, no conversion as a crime could have existed, just especially automatic, because you're a party where consideration wasn't given. If you could into the NREM of the matter, and so if you never saw a verified claim and you're not sure if anyone received a claim, and that we the people who's living where private trust is, it should be this is what's carried out. It's more communal, and most of it's absolute, that it's in trust and it's private. unless somebody has a claim against that, because they'd say that didn't exist or something. But otherwise, you'd have to have a claim against that to be able to get more further into something which is private, which is in your trust. And this is three-dimensional, because you're acting in your own living capacity, and you're asking for, a ministerial visitation to be able to settle the matter. So these are things which make things more simple, my God, and you're given a proper process because that's what you chose. Otherwise, what self-defense anyone has, where any neededness is, how can anything be exercised if you don't look at title and see that there's not been a crime of title conversion, and so that you're a man or a woman, and that you own your own corpse, and you're accused of this. So somebody would have to say that that's not so. It's relative to you being a private foreign national. Foreign means outside the corpse. So anyone that's an American, for instance, is a private foreign national, and has property that rights flow from, then, you see. But otherwise, a paperwork has gone on, and it shouldn't stand of itself, because you've got this to be able to say right in an instant, because you can totally understand what the whole picture is. So we're sort of more where Commonwealth law is, and this is the law more of the nation, and these are all laws which is more international. And most people's, what they earn really is of a domestic good, and really isn't, it's a household good, not domestic. Domestic means that it's housed and domiciled in the District of Columbia, and where most everybody is, you've got household goods, and that's what things are, and that's not traded. And the things are that it's probable that somebody is really engaged more where international commerce is. And so what's common where law is, and the protectedness of title, of course, and as a party is as a man or as a woman, it could only be joined with as another party who is as a man or as a woman. But if you've only appeared as a fiction, you could have been joined with something fictional. And most people should really, reject the idea that you're only being left as something, as a chattel. And so a right is only a right that it's upheld, and you or I or anybody upholding the rights which you have. But otherwise, the officers are all under oath to you and protecting you by following what it is that's the Constitution, and then having a privilege for that duty which they're going on with, and also having a responsibility. And so liberty is that you're free to be able to speak the things that you can, and that means you have liberty, because if liberty that you don't have, how did that all of a sudden happen? Nobody could abridge a constitutional right, and any state or anything that went on that it did so isn't really under the Constitution anymore. And so, an oath to where the people really of the county and the state where you are living and you're acting to assist, to help, those in the government and in their private and public capacity, as well as everyone else, to help protect and to help ensure and to help care for where errors could have been. You see, so you shouldn't have any argument, which you don't. It's your private capacity to witness, and where a corpse official is, but you've got also, of course, someone in their person, and are they looking and reading things right for themselves, because they cannot leave that part out, because that's your person, that's where you'd be liable otherwise. So where no title conversion is existing, of course, you've got the venue from the land, and you've got we the people and laws more from the land, and these are more common law. So everything that would have been a tax violation, the crime that's commercial, and statutes and things attest to what this is. You're really more as a living woman or man, and under the condition of being in visitation as a minister, with a minister, and ministerial visitation versus something else going on, but you're certainly special because the bond is put into a special fund, not the general fund, and the clerk of the court is asked to be the one that makes sure that that happens, that you've got a court of record, because you can have this opened up to you. And so the bid, the bond, and the bid and the performance and the payment bonds, and the bid bond itself has grantor on this, and this is where you are. And the CUSIP and Auto-Tris, or that you could learn from and use, they are the various bonds that you could learn how to apply. And so the bid bond, where you are the grantor, you've got a settler as a trust, and the assigned magistrate or judge can be appointed, and the appointment is an appointed to be the settler, and the anybody that would be prosecuting things could be appointed to be the trustee of the matter. And so, otherwise lots of co-jointedness and injunctions could need to be, perhaps, because it could be really that you've objected to where something existed, and most people sure do. Is this claim which you have, where you've got property, and you've explained what that is, and that's supposed to be returned to you. And otherwise, it should be out of probate, because under common law, any trust held is in private, and so the documents and everything that you're putting to be there on the private side of the court. And officers that could see this can see that a trustee, as they are, is existing, and the charges that have arisen are then helping and working for you versus against you. And some value is given, like what we were talking about in the podcast here, for some consideration, of course. And you're agreeing to discharge post-settlement, whatever the costs are, the harm, the injury, and it's harm that you've got. And that's not just injury, damage, and cost, but harm, and that's personal. And so damages that are harm is existed, and these are all things which could be set off underneath a trust that you formed. So like I would form like a Jub AZT trust, for instance, and be lowercase where that is. Or you could, use any name there, in fact, because it's your trust that you could have named. And this is not in the general fund, but in the special funds, you see. And so charges can be set off from this. So the court order really is signed off on, and you might have a court order, please give my property back to me, that some default exists where anything is. And somebody can look to see if any weighted signature came into the file. Otherwise, choose an infant decedent to an infant decedent where hearsay was, which was under probate, all of those things which was only by presupposition that wasn't verified, or become a defective process of it. So if you only have to have one error and it just wipes out whatever that document is. So to satisfy the laws governing a security, it's a crime that you could consider if it incurred. Of course, contraband existed, that something was going on that definitely went past 9 months to have its maturity. And these are things which then, for sure, should be under, the way that it should be done is supposed to be more verified. And you have to have Article 3 and higher verification. And these are all, instruments that's written up as bills of exchange. And so you've got 3-party types of conditioning that should be there to have proper surety and governance over these sorts of transactions and everything. So those are things which can't just go past. Some exception could be, but once the general rule would be that hearsay, that somebody's only an infant decedent and having hearsay with another infant decedent and signing off on those things, that's not a proper procedure or security that most people would have looked at and seen, of course, that there's actual laws that's written to help govern these sorts of things. So conscription, for instance, like a word, it's sort of a word that's being used right now because of the Ukraine incidents and everything. And most people feeling what a meat grinder is and mandates where any son of a purr is or sold year, and anybody that's taken on board themselves a title, which is some action that you are of or something, but not you in your identity proper. So it's individual wherever a meaning is of any corporation. It's an office, and that's just in the de jure corporate government where things are, and a command where request is for an offering. It should be a de jure corporation where the owners really shouldn't be, of course, where somebody's just effectively only got some gain in emulation being funded, but underneath that sort of crimes are going on. And where the people's agreement about things where venues just being taken, like we're talking about in this program. So without consent, no way could be given any obligation, and sort of mandated that it is to have the people's consent and expressed givenness. And most could just be demonstrating, and it's obvious that there is no consent. So after that, you've really got a problem where things are, because you've to have consent. So agreement really is where this is making something more lawful, of course, and it's from the laws of the land. And otherwise, legislation isn't law, it's policy, and it's just carrying the appearance or colour of a consent that's going on with the governed. But it's the law of the land that comes from we the people, and this is you or I in our living selves who sit above the Legislative Assembly where Commonwealth nations are, and a bureau sits above them, and you and I sit above that. And so this is how laws should be made. In the past, it comes from public opinion coming to shape public policy. And this is how the process is supposed to work. And wouldn't you know that many of these need to be to help protect people where they are. Otherwise, the whole show is people are falling on both sides for some fence, and everybody there is sort of innocent to some degree. So it's looking at the empirical crown and where the reset is, it's zeroing out all the debt, you see, and having positive inducted currency, as it should be from we the people. At jubdavid.com, it's probable that you could actually look into this a little bit more, the eclipse movement. But a strange attractor really is there's four types, and these strange attractors come to be expressed because some charge was, you see, and that's a living charge until that's discharged. And so a strange attractor is set up by some charge, drawing everyone forward more like a assemblage point in the future for something to be resolved and expressed. So it's only resolved as something is expressed. So what's positive economic induction is where currency is based in governance, and that governance is decentralized and more from a platform like .arm, which is a platform that everybody owns. And so, it's more in a quantum of today, and unique it is that somebody could have a system that really is more smart contract, and this is the kind of thing that really should go on. And so a JC quantum exists more in languaging, and so you have to look to see how do you use is, because you must have is in a document where smart contract is. And you have to have a real true noun as a name and things as well. And what's a public trust shouldn't be just a block and a chain. It comes to be a public trust instead of just a block and a chain. And so this is what the ARM is about, an alliance of law movement. And most of us all around the earth, wherever nations are, this is actually what everybody wants. And so it all hinges upon the venue where you're coming from. And as you come from the land, this is the system that really could help resolve things and always be in a child's best interest for sure, rather than a system that just sucks energy for its own self and causes those officers and people that get caught up in all of this only to be primed and be like an opposition and things. This is just really completely separating people, which of itself is an act and kind of is not right, that anybody could be primed where anyone is to see another as some combatant. It's agreement, which you and I have, no argument exists. And what's post-traumatic stress really is typical, where children are just growing up into adulthood. And the WEF, wouldn't anybody say, certain, installed more than 4,000 world leaders. And somebody could do that that's communistically bent, can't they? Because they don't know that in a free world, it should be that, these positions are open to everyone, versus no, we're only, got our voice from the stakeholders, which is CB Cower. It's a criminal banking cartel of a one world order. And so anybody could say where officers are for rent, and they're skiting that all these officers were really for rent. Why? Well, because they're saying that 4,000 at least of these leaders all were indoctrinated by them. And so could you say that there was no help where somebody was to get to the position where they were? Is that the reason why they're not really getting a foreign agent's insurance registration like they should have? Because every single thing they're doing is engaging with the people's surety, and you're supposed to be upholding, the laws of the land rather than infringing upon people's constitutional right, which any state doesn't have a right whatsoever to abridge a right that's a constitutional right. And so somebody couldn't be out there where the world is far away in Davos, saying that they've installed 4,000 world leaders around the world and they indoctrinated them. And so you've got institutions like CCOT, which is disgusting. Most of the world looks at that as that's just a horror. Because why? Because lots of innocents get caught up where something is, and nobody has a right to treat another person as an animal. That's objectification and everything. This is just lost and has no ethic whatsoever. So a lot of things are going on like that because it's all under a corporation, and most of the news you're getting is from a corporation. It's sort of very monopolistic. And the proper structured family always in the past would have a trust, like a family dynasty trust, to protect property from probate. And otherwise, if it's left in the probated condition, it means that somebody's just in their public self under some jurisdiction, and assets, whichever has existed there, is in the public. And so those assets are all fair game to be just sold and drawn off from, to pay anything off that would be existed for you. And so anybody who allows anything that's private to directly be able to be for future generations in a family way that trust would be, the terms of you having ability to easily avoid what would be public and costly and time-consuming because some probated process was, rather than being able to resettle and resolve things, which you've got a central organised nervous system to do that, whereas a corpse doesn't. So that what's irrevocable where a family dynasty trust is, that shields anyone and everyone and your assets from being under a probated condition. And when you're doing things that's like this, you're sort of really having more multi-generational wealth transfer, and you're taking more control of having creditor protection and privacy for your assets, where homes are, and investment and business is existing. So property that's placed more into a family dynasty trust and house really has value, and that's not a probated asset. So where the trust is, it can have its expenses and things, and it can have a whole range of things which it spends money on, and these are things which come to the beneficiaries, and some of that could be income, and what is there then is what should be there, so that it doesn't leave anybody vulnerable not to be able to be received of the benefits that could be existed, under Medicare or Medicaid. Otherwise, the asset which is left in the public domain, which is private but is not looked at as being private, where that is, becomes public value used, and it can really modify what assistance anybody could have to pay bills and hospice and home care and these sorts of things. If everything was just left to be probated and somebody says, I'm only just getting corporate care, it's like, oh my God, this is going to be off the chart. Why? Well, because you just said, I don't mind, and if you don't matter, I'm going to just have something which has got no central organised nervous system managing the whole thing. It's like, this is really disastrous and opens everything up, for errors and mistake, but also greed and avarice from corporations and everything. So somebody who could have some subjectiveness to have some repayment and something certain, where certain types of public assistance is, specifically Medicaid and long-term care sort of benefits, and the process like Medicaid estate recovery otherwise goes on, and Medicaid, not Medicare, but all of this is sort of federal and state programs that cover long-term care costs, like nursing homes and care for the individual, because you've limited the amount of asset that's existed that is in your name, and so that's not coming up to be assessed where something is. So the property of what that is would then be just on sold, and people will take a cut from all of that, and the family won't be left with anything as a result of it, you see. So it's communism that absolutely things are set up so that you're not being able to transfer over any wealth existed unless you understand how to. And so how does a house avoid probate where the value that's existed isn't subject to some recovery where a state's Medicaid or a state recovery program is? It really depends upon, of course, the laws which is there in the state, and Medicaid and these things, and government benefits where the estate recovery is, you see. So a mandate is based upon some agreement, and it has to be just because some consent is. But if consent doesn't exist, then it doesn't exist. It's really an offer which you've refused. And not on for the record, anybody could say that they object to where any other party is of some assumption, and that you're of non-assumption, and that will and testimony of your loved one could be your mother, your father. You were given instruction, and are you acting properly, in the will of your parent or your relative that you're helping where things are, because you've generally got some sort of instruction to help protect property and things, and you can have given people the information to go ahead and put things into a family dynasty trust and given them some insight into that a bit. So easy to do, and somebody could have not done that because they're just unaware that Care is existed unless somebody takes hold of things and they understand the whole picture. They're going to be left in the dust a lot. And property interest, that really is where some note is created. It's an agreement and operation for something that's responsible people are to have performed, and anyone else could say that they could have a claim that could say this claim is wrong that I'm presenting. It's like, wow, well, I don't think so. I can say nobody's going to say that my claim is wrong. And you're just here to find if a claim exists. That's it, finished. So it's as simple as that. Something should be just one page, honest, or a few pages, but not more than that. You're getting a collective agreement. What's on the front page is really has to be the strongest. You've got to have some fact there and some law. Otherwise, who's acting where anyone is a proper guardian of your dad's or your mother's property, for instance, and protecting health choice where things are, and making sure that a second opinion existed, because otherwise it could be an opinion that's conflicted. And in history, it could be that you've got some realisedness that, or you have a belief that something was really adequate, or really you realize, or you become aware that it wasn't. It was inadequate. And the proper informed approach, where harm would have existed, where your relative is, and your relative where this is a beneficiary, you see, and getting a benefit, or no, not getting any benefit from that. So what's said in the way that you put things, and other witnesses are there to be able to see that this is noticed. It's just on and for the record where some benefit is, you see, and you can have asked for these things for your relative, and that the properties that be where something is existing can be assessed properly, and be put into the private trust as your relative could have told you to do. And where somebody didn't do those things, they're not really fulfilling the role properly. And certain it is where somebody would ask for, I think I need to get a second opinion, because, something going forward should really have some verifiedness of itself, and no second opinion existed that wasn't really of some conflicted interest. So to care properly where property is and protect charges that could have arisen, and to order on demand to place all of this sort of under a bid bond that you can post, and that anything that's post-settlement then you've agreed to discharge, and the value given for consideration, how good is that? Because you're agreeing to pay the tax, and you're having your tax deductibleness be used to pay the tax, and that's the value that you're giving anyone in the offices where this is. Because you're looking after them, and that you're getting consideration for this, and this is your remedy. So it's non-assumption. It means that you're not there to be with any assumption. You want fact and authority, and where you've got venue, where this is, you've got jurisdiction, and you've got this over any other claimant. So to know and to have a living witness where this is, and have a date where anything is for something to be resolved, it's really a property interest that's based in law and performance, and where your mother or father or relative is, and where the will is of them that you've heard and that they spoke this to you. And this is the testimony that should be followed where things are, and that should be in a court of record. So there's no challenge where any content is, and you could be just said, I'm happy with a BSAT judgment. How good is that? It means, if somebody thinks something else that comes along, well, they've got a right to come up and say that. That could be good after the fact of this. So I'm just happy to have a BSAT judgment. Otherwise, where a jury needed to be because there was something which was at a loss to come to have agreement, and so then it turns it over to a jury, you see. So to have a common law court of record trial by jury process, and someone could of course, have a lien against what the estate is as a beneficiary, and that discovery really where a claim is. And someone's estate, if it's protected, it would be that you've really looked into the whole picture, and in their life where there's things that could have been supposed to be looked at but wasn't, you see. And this is so important because there can be issues that relate to life insurance and other things which nobody asked about. I mean, that's a right for someone to ask, because some of these things can have been an insurance which was for the Crown's insurance or a state's insurance, and they may not have been obliged to have said that they had that life insurance, but you're a beneficiary of. And any default that goes on can be assessed. You're looking at if anything iatrogenic was, is the history proper as it should be, where someone's medical history is. And otherwise, you're doing this because you've got a reversionary interest in protecting the property because you're a beneficiary of this, and that no challenge arises afterward. Of course, your relative really is there where testimony is, and this is under private trust agreement carried out where simple it is. Some injunction should be put on other things otherwise, you see, until this is satisfied. But time to be given something where you determine, or I could say, my God, I'm positive, I've got a belief that iatrogenic conditions exist that cause this. And so where an estate is, it's certain that compensation that would be or be part of an estate, and it's done and it's witnessed, where a settler is and a trustee and the clerk of the court helpful with all this to make sure the paperwork is put proper. So equity acts in personam, and so your relative really has explicit capacity to have told you to make sure that you're keeping equity and protecting the property. So guarding against any iatrogenic harm, that would be one of those things, wouldn't it be? And you could have other parties that's involved where they are beneficiary, and you're giving equity to everyone. So the testimony really is the property and the family dynasty trust, which you could have time to put things into, and also then you're getting a second opinion to look to see what's gone on where anything is that's been iatrogenic that wasn't maybe looked at. So there isn't really any conflictedness about that, and there can be not really any disagreement, because what would be the reason for that? There's no harm, injury, cost, or damage to them to anyone else, but yet the messages that anybody has where anything is requested, you see, somebody could say there isn't anything cystic fibrotic, but well, a professional person should look into be able to say that, you see. Most others could have never heard anything like that. And when you mention somebody can have some degree of cystic fibrosis, it's because you can have a greater understanding of the meaning of what that is, or someone did. And this is all to do with having and getting a second opinion, you see. So otherwise, people are going to say that something as a toxin wasn't just administered medically, and your relative would have then, if no knowledgeableness about that, would want detoxification and more self-rejuvenation as an approach. But if that wasn't decided, property just placed into a dynasty trust that protects your relative, and everything that you do is about the protection of what needs to be. You're acting as a proper guardian, you see, but otherwise, gee, maybe you're not, you see. So where someone's care is, there can be insurance, and a lien that's existed really is a value that someone has over a property that exists, and that something is owed. And where your relative is did anyone die that was close around them, like their wife or their husband, let's say, and you didn't look in to see if there was any insurance policies taken out by any third parties, and that should you know about that, it should be inquired, and that's why, because that relates to the estate of, the living relative. And so the equity really is directed where a person and public self is, and to prove that you're not a person, or you're accused of being a person, but where equity is served, your relative really is listed as a beneficiary, you see, and then that's in your relative's best interest. Otherwise, no, it's not. They've been listed as a co-trustee of something, and this is just disastrous. So not protecting the property by understanding trust law and knowing how probate would have worked and how that does, and your understanding how to guard equity, it's really a matter, and it can be someone's belief that something like toxicity, which would gone on, should have been guarded against, and some iatrogenic harm can exist. And this all then again relates to what some settlement would be because of that. So like glyphosate, for instance, is a good example, and certainly heavy metal tracer molecules and things which can't be used if they're left in the body. And what's the proximity and time spent where somebody was, where toxins exist, where the air or the water is and things. So that not placing property into a dynasty trust, which your relative should request, of course, it's really the benefit of compelling anybody to act and have refrained from acting in anything which wasn't or given your proper equity interest. So it's really a verifiable claim that somebody has where your relative is as a beneficiary and placed as a beneficiary of the trust, and requesting other beneficiary to have proper lawful, equity protection, and not that to be under equity. But can the court sort of look to see where anything is that no iatrogenic harm was where your relative is, because an equitable interest is to protect property and to do what's ethical, and property which is taken but wouldn't have been protected is really not a proper guardian like you'd imagine. So where no toxin was, okay, but what about if toxin was, you see, and is there any lacked approach? And did that lacked approach sort of really, was it harmful? And where is the second opinion, because it's non-conflicted by interest, and that shouldn't it be something that would be requested? It usually is. And so where drugs are given and they kind of had no efficacy whatsoever because they were completely withdrawn because they didn't work, but these were drugs that was given to someone, now they've completely stopped those because of the harm. And so synthetic estrogens, is somebody going to say that's not the reason why women end up with meningiomas and pancreatic conditions, and they do so far more than men? It is because synthetic estrogens and hormones was given to her. And so these heavy metals where markers go on, like PET scans and this sort of thing, can have left unphysiological salt in the tissue. And so a simple test that shows somebody has a leaky gut like zonulin, wouldn't that be so easy to do? And how about all the food to make sure that no glyphosate is just being urinated out, because that's going to not be working right if it is. So, and what about any tests to show that mold, fungus and yeast has existed where the body is? Simple MAP test and non-ecological intestinal fungus of mold and bacteria. These are things which would be very simple, wouldn't you agree? So looking at living blood can tell you and give you a benchmark and have an observational reference point to base things from more visually. So it's important to assess what the nature of the course of action is, because you have a discovery, and it could be your belief that you've got a proper protection of your relative's property, and as suggested and requested, you see, and how come a nutritional approach could have not been used? What would be the reason why it wasn't? And so on. And for the record, anybody that has awareness or as a guardian proper should be guarding against heavy metals and this sort of thing and synthetic molecules. So proper medical history, could someone say that's been had? And if the reason for some temporary injunction should be existed and requested, but there should be time that be given for discovery that's requested, you see, because compensation could be existed where harm is found. And so the reason for protecting assets where a trust is an equity is that for everyone to be functioning as a beneficiary is supposed to, and your relative is included as a beneficiary. So placing assets more to be protected against a probate court otherwise, you see. So it's a genesee trust and property, and where limited assets are, and then become vulnerable, your relative then may not qualify for some Medicare to cover the elderly care and Medicaid specifically for low-income individuals. It really is equity where it prevails, and anybody must spend down the remaining asset, and that could be just enormous, matter of fact, and contribute most of what someone's income is. And that income can then be given from the trust to help where things are. So Medicare providing care settings, and Medicare can cover costs where nursing homes are to pay for room and board and that sort of thing, and to care for your relative. And this, according like you're meeting the asset requirements, and their assets are assisted, and where medical need is, and so placing property under non-statutory organisation, irrevocable settler trust, might you look into that? Yes, I think you should. So limited short-term help where anyone is really kind of maybe getting health aid and some skilled nursing and getting some therapeutics a bit, and not necessarily long-term custodial care. But then you've got also custodial care where somebody could go into this, and these are the things that go on. Iatrogenic harm could be corrected, and your relative's condition otherwise would have worsened by not falling forward, where anyone would say they had a belief that somebody's got some condition, or where you've got definite evidence that somebody was really having abreactions to taking various cocktails that were prescribed, and the cocktail was so mad that somebody who was normal could never take that without actually being knocked out and made into a zombie. So salt drips could be used, and edema was existing and never that was written down proper, and drugs could have been used that create pancreatitis and exacerbate your relative's condition. Of course, evidence really proving that iatrogenic harm is which caused more health care from the intervention. And isn't this where your relative is, of course, someone who's been able to select the doctor versus no, you only got somebody that was really with more conflicted interest? That's not going to be right. So a second opinion always is asked where that's explicit, and the doctor in charge where something can be of a conflicted interest, and mostly in most courts would look at and say that, you see, because you're getting a second opinion. So the medical record could show that nothing can exist in it properly, and nor even actual observations where somebody did suffer edema from some unphysiological salt drip and this sort of thing. So heavy metals not cleared away, conditions that somebody could have like cystic fibrosis, all of this can exacerbate pancreatic inflammation and meninges where neoplasm is. So clinical evidence can show a slow deterioration has gone on and harm has been to have some cognitive challenge that would be given by cocktail. And those were the things that was prescribed. Anybody could agree to note that a second opinion should be, well, wouldn't you agree with this? So it's really being responsible and receiving meaningful sort of feedback, because that's the effect of your communication. And what's noticed really medically by personnel is more connecting to your relative and have learned from them And did you look to see if any adverse abreaction was going on? And do you know what the meaning of that is? You wouldn't be a proper guardian if you didn't know what an adverse abreaction is, meaning a bad trip from some drugs that you were given. So the cocktail that's given, is any of that counterindicated because it just exacerbated and caused toxic injuries more, and a lot of things was done without anybody's consent. And so these are things that you could have been asked to look into, and do the patient's records where any communication is that you look into. Is any notedness of any abreactions to the cocktail, for instance? Or are those just all absent and not even asked for? So it's somebody's belief that, the medical process could have been inadequate and healthcare professional could have had some failure where there wasn't really any informed consent. And it's somebody's belief that personal injury could have existed, you see, and negligence as to the time that's passed. And so anybody who has some conflicted interest where your relative is, it's really not going to count as much as like what a second opinion more is that isn't of any conflicted interest. But where many tests have been existed, wouldn't you consider that maybe galadium, that heavy metal tracer, and polyethylated glycol molecules could be seen, and you'd have to check for that because nanolipid particle impact where someone's capacity is to be able to, clot their blood properly and for it to be thinned as it's supposed to be. Most of these conditions end up as sort of some blood condition because why? Well, because it's a toxic trash heap. And no nutrition ever come in. And so, it's better that somebody could put something into a non-grantor spendthrift trust and put things into life insurance. How good is that? Now you've got compounding interest and you've got things to grow and you've kept an asset to grow for itself. And the beneficiaries then can be really benefiting from this. So everything today where we've talked about things could be raising questions for you a little bit, and having feedback and inquiries that sort of really guides your discussion. Anyway, I think what we'll be going into a little bit maybe where we are, the next episode could be continuing exploring these ideas a bit and breaking them down. And what's the lawful and health concept that's existing and practical takeaways where anybody is. You've got beautiful life lead protocols which you could look into and strategies of job cell rejuvenation. And, of course, we're looking into how's your mind, how's your mental state, and what are you doing to be able to help guide things to be better and for having personal health and wealth passed on where things are into a complex system otherwise. And anyway, I wonder that you can have a good benefit from the podcast that we've gone over. Anyway, make sure you subscribe and don't miss out on what's coming up that we've got. Love you guys. Catch up to you in a future show.